In today's video, I'm focusing on a very worrying trend which we've picked up over the last few weeks, where mainly mothers who have relied on their children's British nationality and have used their British passport to apply for leave to remain under Appendix FM, usually under Appendix FM EX1. They've had their visas cancelled because the child's passport has either been revoked or cancelled. And this is very concerning. So over the last few weeks, I've seen at least about 8 mothers who have come to the office to see me because their leave to remain has been cancelled and their child's passport has also been cancelled. Now, as you will know, the way to British nationality for a child is defined by the British Nationality Act 1981, specifically Section 59A, refers to how a child can acquire their nationality through their parents, either through their mother or through their father. But the cases that I'm referring to mainly is the mothers. So if a mother is relying on their child who has a British passport or British nationality under Section 1 of the British Nationality Act, then it seems that the Home Office are now using a very insidious way of inviting this woman to an interview and subsequently cancelling the passport. This is what we've picked up. So a mother gives birth to a child. She's not in a relationship or married, and therefore usually the father will be the named person on the birth certificate. Under the British Nationality Regulation Proof of Paternity 2006, as amended by the 2015 regulation, with reference to Section 59A of the British Nationality Act. If a mother gives birth to a child and the mother and the child's father goes to the registry to register the child, in this case the mother is not married to the father, the named person or the named father on the birth certificate will be deemed to be the father of the child. That's what the law says. Both Section 59A and also Section 2A of the British Nationality Proof of Paternity Regulation 2006 are very, very clear. That is what the law says. However, in some cases, which I've indicated earlier, these mothers are being invited to an interview by the Home Office, at the Home Office, and usually they also invite the named child's father. Clearly, he may not have anything to do with the child because the mother may have sole responsibility or the primary carer of the child. But then subsequently, after this interview, whether the interview went well or not, they then write to the passport office, and then the passport office subsequently cancels or withdraws the child's passport, which means that the mother's leave to remain under Appendix FM, usually under Appendix FM EX1, is also cancelled. But the sad situation is that they do not therefore give them a right of appeal. As everybody will know, application under Appendix F are human rights application. And therefore, if a human rights application is refused, they must get a right of appeal under the law. But they don't give them a right of appeal. Why? Because they then certify the decision and say that because the child has lost their British citizenship. Now, there's a difference between a British citizen and a British passport. Of course, you must be a British citizen before you hold a British passport. However, because they've cancelled the passport, they then claim that the child is no longer a British citizen because they don't believe that the father named on the birth certificate is the father of the child. What do you do? When this happens, there are 4 main things that you must do. First of all, you must challenge the decision. How do you challenge the decision? The initial way is not by an appeal, but by judicial review. Under the pre-action protocol, you need to write a letter to explain why they are wrong. Why they are wrong? Because the law is in your favor. Both Section 59A of the 1981 Nationality Act and Section 2A of the 2006 regulation amended by the 2015 regulation says that the child's father is the man who was named on the child's birth certificate within 1 year of the child's birth. So if the name of the father came on the birth certificate within 1 year of the child's birth, then clearly they are not wrong. In certain instances, they are asking them to take a DNA. Let me explain. both the Home Office guidance on DNA and HM passport guidance on DNA says that DNA is voluntary. Indeed, it says that the government has no power to request a mother to take a DNA test for the child and the father, because in cases the father can, refuse to take the DNA. It's not compulsory. The second thing I will say to you is that you can also take the case to court. You can ask the family court to determine who the father of the child is by making an application for determination of paternity, where the court's determination is that the father is the father of the child. The Home Office and the Passport Office will accept it. So the things that the Home Office are supposed to accept are: 1, a birth certificate with a named father which was acquired within 1 year of the child's birth. 2, a court order from the family court determining that the father of the child is indeed the father of the child. And 3, it's up to you if you want to take a DNA test. But again, the Home Office have said that DNA is not conclusive, because under Section 59A, if a woman gives birth to a child, the child's father and the woman is married will be the husband of the mother. That is why DNA is not conclusive in these instances. Please don't suffer in silence. All I'm saying is that this is happening, and I wish that people will challenge this, because it's totally wrong for the Home Office to invite you for an interview and then refuse your child's passport. When that happens, please seek legal advice. If you're invited to the Home Office for an interview, always seek legal advice, because that way you will be fully represented and your rights will be respected by the HM Passport and Identity Office. I hope this helps you. But if you need further advice, please do not hesitate to contact us on the numbers scrolling. Thank you.